everyone, welcome. As we're waiting for people to join, feel free to introduce yourself in the chat. You can add your name, your title, and where you're joining us from today. And again, folks are welcome to introduce themselves in the chat. You can add your name, your title, and where you're joining us from today. We'll get started in about 30 more seconds. All right, thanks, Michelle, for starting us off. I know it can be a little nerve-wracking to be the first one to add yourself to the chat. Thanks, everyone. All right, and I'm loving to see the enthusiasm already for our fabulous speakers, who I'm excited to introduce you all to in a moment. So again, welcome everyone. Thank you so much for joining today's Legal Network for Gender Equity webinar, Technology Facilitated Abuse, Recent Developments in the Law, and Guidance for Supporting Survivors. I'm Lizzie Vogel, Senior Counsel at the Times of Legal Defense Fund and Legal Network for Gender Equity team at the National Women's Law Center. I'm thrilled to be welcoming you all today to learn more about this very timely and important topic. Before we dig in, I want to extend my thanks to those of you who helped make today possible. So first, to our attorneys in the Legal Network for Gender Equity, thank you for being here today and for all the work you do on behalf of survivors. Thank you to my colleagues at the Law Center, including Danny Stewart and Jennifer Mondino, who helped make today's webinar possible. And thank you to our fabulous presenters, like I said, who I will get to introduce you to in a moment. A few housekeeping notes. So today's webinar is being recorded. We will share the recording and the slides from today on our website within the next few weeks. As always, you can find our past webinars and other resources on our website at the link that Danny is going to be adding to the chat momentarily. And that's where you can also find this webinar recording once it's ready. We will have the chat function and Q&A function available today, and we'll have dedicated time at the end to answer your questions. So as folks have pointed out, there are so many impressive and wonderful things to say about our speakers, but I'll keep my introductions brief and introduce you to them in the order you're going to hear from them today. So there's a longer bio for each speaker, which we also sent out by email and will be on our website as well, and that will appear briefly on the screen. But let me just introduce them briefly now. So first, I'd like to introduce Dr. Mary Ann Franks. If you can go to the next slide for me, Danny. So thanks so much. Dr. Franks is an author, a professor at George Washington Law School, focusing on intellectual property, technology, and civil rights, and the president of the Cyber Civil Rights Initiative. Next, I'd like to introduce Annie Saifola. Ms. Saifola is the founder and owner of Incendi Law, a woman-owned, woman-led law firm that specializes in fighting powerful predators. She is also an author and the co-chair of the New York Cyber Abuse Task Force. And finally, Lindsay Song. Ms. Song is the Associate Program Director of the Family Law Project at Queens Family Justice Center with Sanctuary for Families and the other co-chair of the New York Cyber Abuse Task Force. And all of our speakers are nationally recognized experts on today's topic. We're really lucky to have them. So a brief overview of what our speakers will cover today. So first, Dr. Franks will provide updates about recent legislation and litigation regarding technology facilitated abuse. Then Ms. Song and Ms. Saifola will talk about recent trends and how technology is being used to further abuse and strategies and tips for litigating attorneys who represent survivors of this type of abuse. And before I pass it to our speakers, we first just wanted to get an impression of a sense of who's in the room today and get a sense of your experience around this issue. So Danny's going to launch a poll, and it's anonymous and optional, but we would love if you could just tell us, have you represented a client in a case that involved technology facilitated abuse? Yes, no, or maybe you're not sure. We'll tell you more about what technology facilitated abuse is if you're not sure. Great. These responses coming in. Interesting. So it's a fairly even split between yes and no, and then some folks who also aren't sure. So again, I'm glad we're going to have a really comprehensive description of what this abuse is and how to advocate for your clients who've experienced it. So thank you for answering that poll, and I will pass it on to you, Marianne, to get us started. Thank you.
Thanks so much, Lizzie, for that introduction. It's really a pleasure to be speaking on this panel with Annie and Lindsay, whom I'm huge fans of. And so this is a great chance to interact and to learn from them, and I really appreciate that. I'm gonna do a little bit of a legislative update and give a couple of updates in terms of some policies that might be interesting for this audience, as well as to talk a little bit about one case, at least from the Supreme Court, that may have some bearing on some of the work that many of you do. Obviously, technology facilitated abuse is a pretty wide range, a pretty big category of potential conduct. What I'm focusing on for most of my remarks in these legislative updates is image-based sexual abuse, which is where I spend a lot of my time and thinking, and where the Cyber Civil Rights Initiative focuses its energy. And but I will talk a little bit about some of the kind of adjacent behaviors to those. But to give you an update of where things stand, and this is a note too about some of the changing terminology, but we are now at 49 states, plus the District of Columbia, Guam, and Puerto Rico, the Uniform Code of Military Justice, that have criminalized some forms of what we are trying to call, or trying to shift to the terminology of non-consensual intimate imagery. So essentially, authentic, private, sexually explicit, or nude photos or videos that are distributed without someone's consent. When we started our work, Cyber Civil Rights Initiative, back in 2013, some of you have been around since then doing this kind of work. You'll know that there were only 3 states that had laws against this kind of abuse. So we've come a long way. Many of you will also know that some of those laws are better than others, and that we are still struggling to get some of the less good ones to come up to the standards that we would like all of these laws to have, to match more closely with the CCRI's model statute. The main issue there being defining the crime properly. That is, making sure that the focus is on consent rather than intent. That is, making sure that it's defined as distribution without consent, as opposed to requiring that the abuse happened because someone had a particular agenda against the victim, that they intended to harass or harm them. We've been trying very hard to keep those clauses out of the laws because that is an overly restrictive definition of this abuse. And one of the major movements in this year was Massachusetts, and there was a fight to the very end about whether or not the intent to harass clause was going to be kept in. At the last moment, it became an or as opposed to an and so we're very happy that Massachusetts is in pretty good position with its law that it passed this year. If you're wondering who the holdout state is, it's South Carolina. So if you have any connections there, we should talk. The other couple of things to note is that we now know that 30 states also are addressing what we, again, in an attempt to try to be reflective and intentional in our terminology, have decided to call sexually explicit digital forgeries, but are more popularly known as deep fakes. There are many places that are either updating their non-consensual intimate imagery laws to include artificial imagery or machine learning generated imagery, or creating independent actions to address this, both civil and criminal. So there's about 30 states. It's changing all the time. Again, there's a kind of, it's good to see this kind of momentum, that there's this much legislative energy around this. Some of the laws are not particularly good. A lot of them will probably run into some constitutional challenges, but it is something to note that a lot of legislatures are looking at this issue. For those who might be interested or have connections to legislators, the Cyber Civil Rights Initiative has developed model legislation on sexually explicit digital forgeries that we are more than happy to share, and happy to look over proposed bills as well. The other thing I want to mention happened a couple years ago, but it's something that has not gotten that much attention, but it is the federal civil remedy that was passed as part of the Violence Against Women Reauthorization Act back in 2022. We had hoped that that was the year that we would get both the criminal penalty and the civil remedy for non-consensual intimate imagery. The criminal part got stripped out at the last minute, but the civil remedy does exist and has been used, I think, at least in some occasions since then. So there is a civil federal remedy now for non-consensual intimate imagery. Can we go to the next slide, please? So speaking of federal legislation, what we have seen in the last year has been a lot of movement actually in some good directions for taking the problem of image-based sexual abuse seriously. Now, all of this that is listed on the slide here, these are not the only bills that have been proposed or have had some movement in Congress, but these are the ones that I think sort of really capture a lot of what it is that we are trying to do at the Cyber Civil Rights Initiative in terms of legislation at the federal level. And just as kind of a background note, because it may seem non-obvious, why, if we're getting legislation in all of the states, why do we think it's important to get federal legislation on non-consensual intimate imagery? And the answer to that is partly that the kind of patchwork that you get from all of these state laws with varying definitions, varying levels of severity, creates a lot of confusion for victims. And because there's so much of a borderless aspect to much of image-based sexual abuse, it's often hard to know which state is going to actually control, which state law will control in a given situation. What we really want from the federal legislation is one uniform definition that is correct and efficient and provides not just an actual path forward for the people who are facing this kind of abuse, but also educates the public about what this really is, that it is, of course, sometimes a form of harassment, but it's always a form of a violation of privacy. And that's the most important thing to keep in mind, that our intimate privacy, as my colleague and the Vice President of Cyber Civil Rights Initiative says, intimate privacy violations are as important as other kinds of privacy violations, at least as important. We think about our financial data, our health data, lots of things about ourselves that we would like to keep confidential or limit to a certain audience, and it should be the same. The same protections at least should apply to our intimate privacy and our information. So we have for some time been calling upon Congress to pass a federal non-consensual intimate imagery law that's had a bunch of different names over the last few years. It now in the last few years has been called the SHIELD Act, and would essentially do this. It would make it a federal crime to distribute nude or sexually explicit images of a person without their consent. It did pass the Senate in July, and that is good. There was a big fight at the end among all kinds of holdouts, but there seemed to be some consensus towards the end that this was important. So that was a very encouraging sign, but it has not yet been taken up by the House. And as I'm sure you all know, we're running out of time. December 20th looks like the last day that the bills that have passed this year could be brought forward. So we are hoping that this is going to be a moment where that actually does happen and we finally get this bill that we have been asking for over a decade. So that's one piece of legislation that we're keeping a very close eye on in the next few weeks, or the next couple of weeks that we've got left. The other is the Take It Down Act, which is a bipartisan bill as well that was passed just recently out of the Senate. I think it was a couple of days ago. And Take It Down does a lot of what SHIELD does, and it does some of the things that SHIELD does, and it adds to it the manipulated imagery issue. So the part that is less than what SHIELD does is that it doesn't deal with all distributions of non-consensual imagery, only publications to social media and websites. And what it does do that is more expansive than SHIELD is it also deals with not just authentic, actual truthful information, but also with manipulated imagery. So it gets at the deepfake question. It's not just a criminal provision, it's also a civil provision, and it's also it's a criminal provision and a provision that would force certain companies to remove within 48 hours credible reports of this kind of material on their platform. So it goes quite a bit farther, and generated a lot of controversy for that reason, but then, as I said, passed the Senate and may get a vote soon. The other piece that we're watching is the Defiance Act, which is a civil remedy provision for deepfakes. So it would be exclusively focused on artificial intelligence generated sexually explicit imagery, and that passed in July. It has been championed by a really wide range, bipartisan range of members of Congress, and it looks like its chances might be quite good. The position that the Cyber Civil Rights Initiative has taken on that is that civil remedies are very important, but they are by themselves not enough. So we do not object to the fact that this is moving forward, but that we really do hope that there will be a criminal provision there as well, in part because our research has shown that the fear of criminal penalties is the most powerful deterrent of this kind of behavior. One of the things that we emphasize at the Cyber Civil Rights Initiative, of course, is how devastating and in some cases irreparable the harm is once someone's private images have been published, or whether a deepfake image of them has been published. And that leads us to putting serious emphasis on the prevention aspect of this behavior, because they're really, no matter how good our laws are going to be in the end, if they only come into play after something has already happened, they're always going to be of limited use. And we're very concerned about any remedy that relies solely on the ability of a victim to be able to bring a lawsuit and to have those resources to be able to do so. That leads me to mention the Preventing Deepfakes of Intimate Images Act. There's a version of this in both the House and the Senate, but it hasn't moved. I mention it because it is like the Defiance Act in that there is a civil provision that would allow victims to sue, but it has in addition a criminal provision that says you cannot engage in this behavior. And so from our purposes, from our perspective, we would say that that's a more comprehensive bill. I will say that there is one difference between the Defiance Act and the Preventing Deepfakes Act that in another direction, which is that the Defiance Act would cover the creation of the sexually explicit digital forgery as opposed to the mere distribution. And that is an aspect of defiance that we think is very strong and probably should be integrated into an ideal bill that would deal with sexually explicit digital forgeries. The last one I'll mention in passing is a little bit confusing because some of you who have been doing this work for a long time might recognize this name. The original version of what is now called SHIELD was called the Intimate Privacy Protection Act. That name has now been adopted by a member of the House of Representatives who has put forward a bill called the Intimate Privacy Protection Act to reform Section 230. So it isn't actually a bill that would create a crime or create a civil remedy. What it would do is it would be a partial kind of carve out for Section 230 immunity. That is to say, the immunity that many tech companies have from being sued for harms that occur on their platforms. The Intimate Privacy Protection Act would essentially carve out from that immunity any company that did not put into place reasonable measures to address specifically stalking and image-based sexual abuse, including deepfake abuse. Next slide, please. So the other thing I wanted to mention is that there are some resources that are either continuing or have been developed over the last couple of years that probably people know about already, but we want to mention. One, of course, is the Cyber Civil Rights hotline, our crisis line rather, and our online safety center to make sure that people are aware of those resources that are in place. There are the two that I've mentioned below that, stopincii.org and Take It Down. Stopincii.org is one that essentially anyone can use. Let me back up and say these two below, they're basically removal or notification services. So that, and the difference between them is that Stop NCII is basically for adults and Take It Down is for under 18s. Take It Down has been promoted by the National Center for Missing and Exploited Children. It's a service that if you were under 18 in the photo or the video, you can take advantage of, whereas Stop NCII is not limited in that way. But they both use essentially the same kind of technology, which is user-side hashing. What happens is if you know what the image is that's out there of you or that you're worried might be out there, you can send in a hash that's developed on your side to these services. And so what that means is you're not sending the actual image and it's not living anywhere. And it's being sent to this centralized service so that it can then, with all the participating companies, major platforms, it can be sent to them so that they can block it or remove it from their platforms. And this will be technology that is familiar to those of you who've worked in the child sexual exploitation space, the photo DNA kind of approach with some more sophisticated developments. The last thing I'll say in sort of the policy resource update is not really a resource update, but did want to mention that there was a working group that was formed by the Center for Democracy and Technology, the Cyber Civil Rights Initiative, and the National Network to End Domestic Violence And in conjunction with and collaboration with many advocates and organizations, work together to try to think about how the tech industry could better respond to and prevent image-based sexual abuse in all of its forms. And one of the products that came out of that working group experience was what we're calling the IBSA principles, and they live on a site called ibsaprinciples.org. And they were developed with the input of tech companies to try to talk about the values and the principles that responsible tech industry members could have in place when they are either developing the technology or promoting the technology or putting it in use, anything basically that relates to image distribution, whether that's machine learning or not. And the principles try to put forward some of the values that many of us on this call share, which are consent and autonomy and privacy and the ability to be able to report abuse. And so some of you may find it interesting to see the kinds of at least theoretical commitments that some members of the industry are making and who it is who's participated in that effort and how much they may be signaling their more proactive concern with these issues than they may have in the past. And so that may be of use to some of you working in these spaces. Next slide, please. So the last thing that I would like to talk about is one case that some of you may have heard about before. It didn't get as much attention, I guess, in the mainstream as one might expect, but it does touch on some issues of technology facilitated abuse. And that is this case called Colorado versus Counterman. It's unusual in the sense that to the extent that people really did talk about this case, I would say to the extent that people in the First Amendment community talked about this case, because it is a First Amendment case, it was a celebrated case. That is, this is a good result and it was presented as a win for the First Amendment. And this is particularly troubling because if you look at the details of this case, if you realize what it's actually about, you realize what is being said here, if what is really meant by a celebration of this case, what is being celebrated here is something that is, I think it's fair to say, fairly hostile to the notion that technology facilitated abuse is a real and serious thing and has a serious chilling effect on women and girls in particular. So I'll back up to say that what's troubling about that celebration in many civil libertarian communities is that they don't mention what the underlying facts of the case actually were. And that is, in essence, this is a stalking case. So this is a case where a local musician named Coles Whalen, Colorado musician, she was on social media, as many musicians are, as a means of communicating with her fans and to boost her career. And at some point, for over a period of several years, a man she didn't know, turns out that this is Billy Counterman, kept sending her hundreds and hundreds of messages, at least by some counts, it's thousands and maybe even 1 million messages over 6 years. And they were insistent messages that indicated that he thought that they were meant to be together, that they were secretly communicating with each other, indicated that he was watching her. And because she didn't know who he was, she didn't know if he was in fact showing up at her venues or was keeping surveillance on her. And she tried to ignore the messages, tried to block all the accounts. He would just make more and more accounts on Facebook. This is the method of communication that he used. And at some point, she became very withdrawn and frightened about performing because she wasn't sure if he might show up at one of her events and try to hurt her. And she had a lawyer friend in the family check out his record, and it turned out that he had a previous felony conviction for making violent threats towards family members. At some point, she got a gun, she stopped performing, she left the state eventually. And he was charged with stalking under Colorado law, which, as many of you will know, there's multiple statutes in Colorado that deal with stalking. But the particular case here had to do with his communications, not physical conduct, but these Facebook communications. And the standard that the courts used to convict him was a standard that is often referred to as the objective standard, which is, were the kinds of messages that were sent objectively terrifying? And because that was presented as a standard, the answer was yes, and he was convicted for stalking. He objected, he raised a constitutional challenge to his conviction, saying, if you're going to prosecute me for my speech, is the way that he would phrase it, you can't do that unless you show that I intended for my messages to be threatening. And there's some in the weeds kind of First Amendment doctrinal aspects of this that are kind of confusing. But essentially, he was saying, you can't convict me for stalking if I genuinely thought that our communications were welcome or that you didn't mind them or whatever the case may be. So what happens in this particular posture with the Supreme Court is that you get an answer to this question of whether or not he's right about whether he had to intend to terrify her rather than merely it being factually true that he did terrify her or anyone in her position. The Supreme Court, in a decision that went 7-2, says he's not totally right. You wouldn't have to show that he has the purpose of terrifying his victim, but he has to be at least reckless with regard to the risk that he's terrifying her, which in the law means he's got to have he has to consciously disregard a substantial and justified risk that he is terrifying another person. The takeaway for people who know about stalking was that this is devastating because it doesn't just mean you can't prosecute somebody for stalking. It means that it is actually a First Amendment protected right to stalk. Now, to be clear, First Amendment right to stalk if you are deluded enough to think that what you are doing by stalking someone is actually not stalking them, that you think that the other person either welcomes this or will come around. That would be enough to show that you were not reckless with regard to whether or not this person would take it as a threat. So this is an incredibly disturbing case, especially one to be characterized as a win for free speech, because as you can tell from the facts of the case, the result of this behavior by countermen, the effect of it on Coles Whalen was for her to stop speaking, for her speech to be chilled, and for the court to then conclude that actually this is the person who was harmed here and the mistake that was made was that his speech was not protected enough is a really grim reality. And so it's going to take us some time to figure out what the fallout of this actually is. It doesn't mean that all stalking laws are unconstitutional. The court didn't go that far, but that takeaway point of saying it matters what he thinks. So we're back to this point that I mentioned about image-based sexual abuse, that the intent of the speaker is more important than the other person saying, I don't consent to these communications. So the privileging of a perpetrator's intent over the victim's consent is something that we're seeing as a really alarming message. And I know that I'm basically at time, so I'm going to hand it over now to Annie.
Tough act to follow, Dr. Franks. But I'm so excited to be here and to share information with this panel, and so happy to see so many friends and colleagues in the participants list as well. So my name's Annie Seifele. If you don't already know who I am, I get to co-chair the New York Cyber Abuse Task Force with Lindsay Song, who's gonna come up next on this panel. And I also founded a law firm this year and specialize in gender-based violence and technology-facilitated abuse. And so both in my volunteer work and in my professional life, these topics are really important to me and come up a lot. So I'm really excited everybody's here to learn together and to share some of the advancements we've made because of advocates like Dr. Franks and CCRI and lots of folks who are here. We've made a lot of progress. I mean, just in the last like 5 or 10 years, the landscape around technology facilitated abuse has improved so much. And also we have we have a long ways to go. But today we're just going to talk about some of the trends, sort of what we see happening. And well, let's move forward, Danny. I'll just talk about through the slides. I don't need to give a huge introduction without just getting into the content. So cyber abuse or technology facilitated abuse, we use these terms interchangeably. So you'll hear me say tech abuse or cyber abuse. They're essentially the same thing. And next slide would be great. So tech abuse and cyber abuse is the use of tech to frighten, control, bully, harm, monitor, intimidate, or threaten another person. Tech abuse can be an isolated incident or a repeated and persistent pattern. It's important to note that one determined person can cause tremendous amounts of harm in the context of tech abuse. And for a victim, it can feel endless and inescapable. And the sort of caveat we always give when we're educating lawyers, police, judges, pretty much anyone who will listen to us, is that the harm is amplified when the abuser has intimate and specific knowledge of the person they are targeting, meaning that, you know, to sort of like go out to the big picture. I know some folks who are here work in this space, where the cyber abuse task force that Lindsay and I helped to organize. Our focus is really like tech abuse at the intersection of intimate partner violence and gender-based violence. But there's also there's all sorts of types of tech abuse that happen, like in the employment context, for example. It's not always an angry or vengeful ex who is committing the tech abuse. Sometimes these things happen. We see them happen in other contexts, like in disputes that are happening within a company or from one competitor to another. We see these happening a lot to everything good. We see these happening also in the context of our political climate, right? There's certain social platforms that are being used to just, you know, spew hateful speech and death threats and other types of threats to people who disagree about opinions. So all of this could be considered tech abuse, but the real like focus of our work is where tech abuse is gender-based violence. So with that, we can go to the next slide. And some of the indicators that cyber abuse is indeed gender-based violence. There's actually some other recent research I'll provide links for, but you know, most victims of cyber abuse identify as female and suffered severe emotional distress due to the abuse they suffered through digital platforms or online. This is especially true for image-based sex abuse. Lots of survivors say that they were harassed or stalked like outside of the internet, like IRL or in real life, analog, however you want to say it, that what is happening to them online does result in in-person attempts to contact them. And I just want to point out, that's just like a really important sort of theme that we're oftentimes talking about. Our annual conference we put on with the Cyber Abuse Task Force is titled "There Is No Offline," because this is something it's an objection we get less often now, but we still do sometimes get people who say like, oh, what's the harm? It's online. You can just change your phone number. You can just go dark. Don't be on the internet so much. And that somehow if you take those kind of measures that the abuse will stop. Well, first of all, that's not true. The abuse doesn't stop just because you go offline. That's a mythology. But also that I think we have now, especially in the last few years, sort of a more collective understanding and acknowledgement that digital violence, cyber abuse does result in in-person violence a lot of the time. And that can happen on a micro, individual, and on a macro sort of society level. One of the other unfortunate outcomes of cyber abuse, partly I think because it feels so inescapable, is that there are high rates of suicidal ideation, or people who have really severe cases who die by suicide because of being a target of cyber abuse or image-based sex abuse. And queer folks are 4 times more likely to be victims. The other thing I want to say is that, oh shoot, I just lost my train of thought. Oh, there's recent research that shows, and this is something I think people who are advocates in this space sort of always have known, but it's been verified through some recent peer-reviewed research that the kind of like impact, the emotional distress that a survivor of tech abuse feels is the same, and sometimes actually in some cases of persistent cyber stalking, even worse than the emotional and mental outcomes that are occurring for people who are victims of personal physical violence or intimate partner violence. And so it's just super important that it's taken seriously, and that as advocates, especially, that we're pushing back when people sort of try to minimize digital harms as if they're not as harmful as those that are happening, in analog context. Okay, we can go to the next slide. So gender-based violence is about power and control. You've probably many of you have heard me tell the story about a newspaper editor I was talking to one time about a story, an older gentleman, and he said he just could not wrap his head around image-based sex abuse, which we formerly referred to as revenge porn. We don't use that term anymore, but he was just like, but what's the motivation? But what would motivate a person? I think he was like sort of had law and order brain where he thought that like there had to be, what's the financial incentive, or what is he trying to, like he was trying to get to this sort of like textbook story, crime story motive. And when you explain to people that power and control is the underlying motive a lot of the time, it's hard for people to wrap their heads around that all of this is based in just a need to control another person. And in the context of cyber abuse, one of the things that makes it even more, sort of complicated and entangled is, one of the, one of the other mythologies that's often used is like, well, if he was so abusive, why did you stay with him? Like, why did you stay so long? And one of the things that cyber abuse really illuminates is that even if a person is able to secure their physical safety from person or an abusive relationship or dynamic they're trying to escape, that the disconnecting from someone digitally is not so easy, especially when we're expected to have these very online lives. We're to the point now where if you don't have an active online presence or active social media in your real name and likeness, that people are sort of suspicious of you. And so it is true that, that there are real detriments to a person's life if they're expected to just not be online. So all that to say, gender-based violence is about power and control. There are so many types of tech abuse. We cannot even begin to count them. There are so many avenues through which a person ends up getting attacked. So one of the sort of conceptual frameworks that we've been using in our education resources on the Cyber Abuse Task Force is to use these buckets or these circles, as you see in the slide, kind of like the Venn diagram, the many dimensional Venn diagram of overlapping layers. They're not obviously clean silos, but we've just decided to categorize them this way into stalking, harassment, spoofing, and sharing of intimate images or information, right? Sharing of intimate images, I think is, yeah, I mean, for good reason, is sort of considered like the like highest, most harmful and most cruel thing that a person can do to maintain control over you. And it's important to remember that sharing of intimate information is also very harmful. A lot of people stay in abusive dynamics because they've been threatened with the disclosure of secrets that were shared in the context of a intimate relationship, right? We share all sorts of things in the context of an intimate relationship, as you should. That's what an intimate relationship is for. We share all sorts of things with our intimate partners that we don't share in other contexts. And so that kind of information can then be used as leverage when an abusive dynamic comes about. So that is, and I just also wanted to say that I know a lot of folks here participate in these webinars and get information from the National Women's Law Center not in the context of domestic violence or intimate partner violence, but also other areas of law like employment law. And I just have to say that all of these dynamics that exist in intimate partner relationships also, many of us here have seen them impact either the intimate partner abuse starts to impact employment. That is something that I am personally a survivor of myself, and many folks are, or the same kind of power and control dynamic can happen inside of an employment context with a supervisor to an employee, or anybody who has sort of power over another person. These kind of dynamics can show up, and we're seeing more and more that this exists in the employment context. And you should know what in your state, like in New York, where I practice law, both the New York City human rights law and the state human rights law have protections in place so that if a person's employment or housing or all sorts of other areas of their life are being threatened because they're a victim of technology facilitated abuse or image-based sex abuse, that they have protections. And so it's really important to know what those protections are wherever you're practicing and advocating for folks. Okay, next slide. We'll move through these ones a little more quickly. These are just some examples, sort of like some composite sketches that will sort of help give you an idea of how tech abuse shows up in a lot of the cases that we handle. A tech abuser will use tech platforms to contact the victim's friends, family, or work colleagues when the abuser can no longer get access to the victim directly. This is probably one of the most common forms of tech abuse. Once a person has, put themselves outside of the reach of the person they're trying to avoid, other avenues through digital platforms become available. and are used to continue contact. Next slide. A tech abuser will, oh, here we go. Create spoofed or impersonating phone numbers and email addresses to continue to communicate with a victim even after the victim has blocked the user. This is sometimes one of the most, like frightening and overwhelming things that will happen to a victim will be that we sometimes call it a multi-channel attack, which is just a fancy way of saying the abusive individual has created lots of accounts, a Facebook account, a WhatsApp account. They've spoofed text, phone numbers through apps that are available where you can, for free or a very low price, make an unlimited number of spoofed phone numbers to continue contacting someone. And even though it's just one person who's behind all of this, to the target, it can feel like completely inescapable, and like a lot of people, more than just one person, is attacking them with information. And the other thing I want to say here that's really important is spoofing technology is not necessarily complicated. It can be very technically complicated if someone's using layers of, obfuscation, like VPNs, and like there's ways to do it that are more like in a high-tech way that would make it hard to track. But most spoofing technology comes down to someone being able to make a username and password on a free platform like Facebook or Instagram or Gmail, and then using those to just create like a very, very, like the most simple type of mask. It's not hard, and that's later we'll talk about trial advocacy, but one of the things that is like the most important to do when you're advocating for victims of this is just to explain, is almost to like, don't get bogged down by the technical details, because it's actually very simple and straightforward what's happening. And it can, even though it can feel like complicated, it's oftentimes not. Okay, next slide. A tech abuser will threaten to reveal private and or embarrassing information about the victim to public forums if the victor doesn't meet the abuser's demands. This is also really common in the context of employment. A person will threaten to reveal embarrassing information or disclose a person's nude images to their employer if they don't XYZ, right? These are sort of very, very, they've almost become so common threats that a person is living under when they're a victim of tech abuse. And next slide. Can we move to the next slide, Danny? Sorry. Oh, there we go. Sorry, I didn't see it. My bad. A tech abuser will use spyware to stalk or spy on the victim or gain access to victims' accounts to obtain private information, eavesdrop on conversations or location. This is a really, really common one. Oh, we're good. Oops, sorry. We can move to the next slide. We're going to talk more about stalkerware in a second. A tech abuser will create impersonating accounts of a victim and make outrageous posts to make the person look crazy or even criminal. This is one that really gets used in the most harmful ways and oftentimes gets overlooked, but it's quite easy to impersonate another person online, especially if you were in a very close working relationship or intimate partner relationship with that person, or if it's a family member, because you know things about them, you know how they talk. It's not that hard to get photos to make it look like you're that person. And then you can impersonate them online and make them look in any variety of negative ways. We oftentimes see this in the context of high conflict divorces and such. We can move on to the next one. We'll just go through these really quickly. Actually, can we just go through to the next slide? Yeah, there we go. I did mention earlier spyware. This is something that advocates are really trying to combat, because spyware is so awful and malicious and difficult to detect and remove. I'm going to take a pause from talking for a minute, and we're going to just watch a couple minutes of a YouTube video that shows how this spyware tech can work. Oh, can we turn on the volume? I'm not able to hear the volume.
I'm not either.
Sorry, one second. Let me try to fix the audio for us. It's very loud on my computer, so I was like, this is great. Just one moment. Mhm. Okay, I'm gonna take us from the top, and let me know if y'all can hear it in the chat or not.
So, you want to keep an eye on your loved one or your employee because you suspect they're hiding something and it might get too late? How do you know where they are or what they're doing right now? Maybe they're not really telling you the truth about their activities or whereabouts. You are worried, so you wonder if the only way to find out is to know what they do on their cell phones right away. You know that's the only way to give you all the answers. What you need right now is a solution that lets you uncover the truth by secretly monitoring all the activities of your loved one or employee and lets you know their location at all times. Don't worry, there's a powerful solution and it's called Stealth Genie. The most powerful cell phone spy software available on any iPhone, Android, and BlackBerry phone, especially designed for you, but also used by over 100,000 satisfied customers. So how does Stealth Genie mobile spy software work? It's simple. You install Stealth Genie spy software on the phone you want to monitor once, and you will not need to access the phone again. As soon as you install Stealth Genie, it will instantly start to upload all the information from the phone you're monitoring. You can view all this information straight away by logging into your online Stealth Genie member panel. You will remotely control the phone. You'll be able to record and listen to their calls, view their call history, SMS log, emails, contact book, appointments, internet browsing history, photos, videos, and instant messenger chats. Read iMessage conversations. Read WhatsApp conversations. Instantly find out where they are by tracking their GPS location. Even better, you'll receive alerts when they leave a certain area or enter a prohibited location. Receive instant alerts when a suspicious caller is calling or texting the phone. Stealth Genie is so powerful that you can even listen to the phone's surroundings from your
Thanks. I mean, we could keep watching, but it's just horrifying. And so it's mostly just to give you like a little taste of how these technologies work. That was, of course, for Phone Genie, which is an app that was removed from the App Store a while ago. You might have figured that out from them mentioning BlackBerry as a platform that it was active on. But there is a pretty big advocacy effort right now to get spyware removed from app stores, putting pressure on Apple and Google so that this kind of technology is not available. But in the context of employment and parents to their children under 18, there's actually like a lot of leeway around the extent to which a person can be essentially stalked or monitored on the devices that are under the control of the person who either the employer or the parent. So it's just important to know. Now, the one caveat I want to give, which is spyware is really, really scary. And if someone has spyware, on their devices, it's really hard to detect and get rid of. But I want to skip forward to slide 25. Danny, do you mind if we just go straight to there? This is just, and then I'll wrap up and hand over to Lindsay. No, one more, the one before it, 25. Yes, that one. Thank you. Oftentimes when people come to us for help, they think that they're stalkerware on their phones or their devices or their laptop because they just can't figure out how the person who is their tech abuser knows where they are all the time and seems to know everything about them. And so the immediate sort of reaction is they must be stalking me through stalkerware or spyware. And really very, very, very few times we're able to actually find spyware or stalkerware. It does happen, but most of the time we're finding that people are being surveilled or stalked through connected apps. And these are the kind of apps that again, with family, friends, roommates, oftentimes connected apps are shared to conveniently order things collectively or, have things sent to your house. But if you look at this selection of apps that are commonly used, they also show what you're doing, when you're doing it, and oftentimes exactly where you are contemporaneously, where your food is being delivered at what time, where your Uber is dropping you off and at what time. And oftentimes these apps allow, especially if you don't have two-factor authentication set up, they allow a person to log in with a username and password. Sometimes people can log in with other things, like if you notice, people can log in with key accounts, like log in with your Google, log in with your Facebook. So a tech abuser could hypothetically have a username and password for one of your key accounts, and then be able to get into all sorts of connected apps that share lots of information, especially location data. So it's just important to note when you're doing, especially when you're doing safety planning with folks who are being targeted by tech abuse and surveillance, that you do a very well-informed sort of diagnostic before you start telling someone to do something. Because we have had, I'm sure any of you who work in this space know that a victim walks into a police precinct, have heard the story where a victim walks into a police precinct and says, I think I'm being stalked through my devices. And they say, oh, we'll just get rid of your device and get a new one. It doesn't happen as much anymore, but it still does. And if a person has access to, is inside one of your cloud-based accounts, getting rid of a device is not going to make a difference for your safety. So just to point out that there are multiple ways that surveillance is becoming a lot more common and available for people who are victims of tech abuse. So that is all for, I think those are all the things I'm going to go over. And the slides have other sort of mentions of things that you can learn about and tech that's being leveraged to cause harm. And I'm going to hand it over to Lindsay.
Thank you very much, Annie. And I will take the remainder of the time to talk a little bit about strategies and tips for those litigating. Could you go to the next slide? So we're going to talk a little bit about evidence collection and litigation, but first, what are we collecting evidence of? Next slide. We're going to talk about some criminal law examples, also civil law, family court, which is what I do a lot of as well. But one example, and we'll get to the next slide for those of you that are not in New York and are in other jurisdictions, but this is just a sample of what New York has done. One example is unlawful dissemination or publication of an intimate image, which is New York Penal Law 245-15, has some similarities to other jurisdictions. As Dr. Franks pointed out earlier, some laws are better than others. Ours does unfortunately have an intent to cause harm element, many others do not. This makes it a crime to share someone else's naked or sexual images without their consent, and it does require proving an intent to cause harm, depicting unclothed or exposed intimate parts or sexual conduct. It does now include images created by digitization, which is great. New York is one of the states that has added quote unquote deep fake images, although a term that advocates prefer is, either authentic or inauthentic images, because the idea of real versus fake, it doesn't actually matter, right? Whether or not it was created by a computer or AI, because the damage is just as heavy and can be just as convincing as if it is created by digitization or not. The victim must be identifiable. It must be disseminated or published without consent, which is important. It's at the point of dissemination or publication, not at the point of taking the photo or video. That could be an additional crime, right? If there's a sexual assault or an image or video is taken without the knowledge of the person that's done it, and that they knew or reasonably should know that the image was to remain private. Next slide. And again, as Dr. Franks very thoroughly explained, all 49 states and DC and 2 territories also have laws against non-consensual distribution. Cyber Civil Rights Initiative, which I know several folks are from here, yay, shout out to their amazing resources. They have a very helpful tool with information on state-by-state laws. And as we've noted, my humble home state of South Carolina is the only one remaining without one, so we are working on that. Next slide. Also, we could be talking about collecting evidence of for a civil litigation, right? So one example, New York civil law, Civil Rights Law 52B, also regarding unlawful dissemination or publication of an intimate image, mostly the same elements as the criminal penalty under 245-15, except that the private right of action also includes threats to publish, which is something that on a state level we were not able to include. Some states included. It was not a battle that we won in New York, but it is included in the civil remedy portion. It also amends the civil rights law to allow victims to bring an action or special proceeding to require a website to permanently remove an image or video. Only injunctive relief, right? Because Section 230 would not allow for damages against a website or social media company, et cetera, to be sued for damages, but it does allow for injunctive relief to remove the actual image. Next slide. End Cyber Abuse, which is a great collective of nonprofits, lawyers and advocates, does have examples on civil remedies for image-based abuse and examples from different jurisdictions available on their website as well. So if you're also looking for your own, I see many civil attorneys in the chat, so I'm sure a lot of you already know what your civil laws are, but if you're curious, you can use this as an example. Next slide. And it's really important to note that there are other laws that we're not going to be able to talk about the panoply of laws that may be impacted by technology facilitated abuse. These are very specific to image-based abuse. Technology facilitated abuse is a much broader form of harm, as Annie discussed earlier. Offenses against the right to privacy, unlawful surveillance, taking videos or images without someone's consent or typically their knowledge. At least in New York, it's without their knowledge. Dissemination of such of an image, those have much higher, at least in New York, requirements for intent, very specific requirements for intent and location, such as a landlord doing it in a space they're not allowed to be doing that, in a changing room, in a bathroom, tampering with private communications, aka forms of wiretapping, but also more broadly something like harassment, right? So in New York, harassment in the second degree is engaging in a pattern of behavior that causes annoyance or alarm to the other person. And so that could, in theory, if there are multiple elements, multiple instances of incidents that are causing the other person harassment, annoyance, and alarm, that could be harassment in the second degree, or aggravated harassment if it involves threats. Coercion, simple as if you do X, which is something you're legally allowed to do, then I will do Y, which is commit a crime against you, or vice versa, right? If you I'm going to force you to refrain from doing something that you legally have a right to do, and then I will commit a crime against you or hurt you. That could involve intimate images. It could involve other forms of technology abuse, right? Stalking, repeated contact, or following. That could also involve online and remote communications, which we see all the time in the context of car trackers, remote vehicle usage, iPhones, Androids. I mean, really, all of us have. I think most people have some kind of smartphone or smart device, and that can also lead to following and stalking through electronic means. Witness tampering is one we also see as well. If you go to trial, if you pursue this criminal case against me, then I'm going to release your intimate images. I had a client who many years ago had been in an intimate relationship with her partner, and they had broken up, and he said, if you ever go to court to get custody of the kids, I'm going to show everybody what a whore you are, and threatened to release intimate photos of her that had been taken during their relationship when things were good, 15 years prior. And he did exactly that. We went into family court for a custody matter, and he printed out naked photos of her and tried to show them to the judge. Luckily, the judge in that case immediately saw that what was going on and entered an order upon my request for there to be no dissemination of intimate images, and it pretty much stopped it. But unfortunately, we see this a lot of, I've even had attorneys say, well, I'd hate to have to bring out these images in court, these images that were taken of your client. And we've been able to shut that down. But a lot of people, this is what people are experiencing. They don't understand that that is actually a crime, right? It could be witness tampering to prevent someone from bringing a case that they are otherwise entitled to do. Next slide. So now that we know what kind of evidence we are talking about and for what crimes and civil remedies, we're going to talk about some best practices for litigating these cases. Next slide. So some general concepts, one piece that I think is really important is not to get discouraged by technical details, which can feel overwhelming at times, and also, frankly, can be overwhelming to jurists and even juries, judges and juries, law enforcement, others that you're going to be advocating for, in front of, and speaking to. It's really important that at the end of the day, all advocacy is about good storytelling. So using testimony and evidence that tells a judge, whether it be family court or criminal court or civil court, a story that makes sense, that shows the dynamic that you are trying to demonstrate, and illuminates what might be the unseen harms of tech abuse, which may not be something obvious. And I think, again, as employment attorneys, many of you understand, the impact that the different forms of abuse and harassment can have on clients, even if it's not as open and obvious as, well, now I have to change my phone number. But am I, keep staying up all night because I'm trying to block this person from messaging me? Or am I having to create email filters that prevent these emails from going to my inbox because it's overwhelming? Or going on, Twitter, formerly, currently known as X, or any other social media, and trying to block and remove all these pictures, that is exhausting me. I'm not able to do my job. I'm not able to go to work. I have to take leaves of absence and I'm not being paid for them. There can be many ways in which tech abuse can be extremely damaging that may not be obvious to an external observer at first glance. Next slide. So regarding evidence, kind of 2 or 3 major steps in evidence: finding it, preserving it, and admitting it. So first we'll talk about finding evidence. So sources of tech abuse evidence. Big one is the client themselves. I mean, that's really honestly the primary form of where we find tech abuse evidence, where we are able to identify evidence from coming from. Um, Again, looking as broadly as you possibly can into whatever the client will allow you into, whatever they have evidence of, text messages, voicemails, call logs, other applications. I've had clients that have been stalked and contacted across pretty much every platform imaginable. LinkedIn, Venmo requests. I had a client who was on PlayStation, that she was a gamer, and her abuser had contacted her on pretty much every application site, etc., and then logged into PlayStation and sent her a message saying you missed one. So really being broad and thinking about all the ways in which people can communicate. Um, and the ways in which that is going to build your case and identify potential sources. Most of the evidence that we get in our cases for both family court and also potentially criminal court comes from the client themselves, because as we'll get to later, it is quite difficult, as I'm sure many of you know, to get subpoenas to be successful from social media companies, from from email, from tech companies generally. Just records are destroyed or are not otherwise accessible. And so it's much better if we can get it from our clients directly, as long as we are, again, we'll talk about this later, collecting it in a way that allows it to be introduced in court later. Photographs, videos, recording of phone calls. One thing as well that I think about all the time is, calendar applications, being able to go back in so clients can rebuild timelines. That is a really critical one. How many, approximately how many times were people being contacted, even having them go through their photos and identifying, oh, I remember that this person contacted me this many times. I remember getting this email or this harassing conduct on this day. It was, my cousin's birthday and we were out at dinner and I saw this email and it got me really upset. Being able to rebuild that through the client's own phones and own applications is really helpful. Looking at accounts on social media, WhatsApp, Facebook, Instagram, third-party websites where abuse occurred. I think this is a large one, especially for not where you're specifically dealing with intimate partners, but business websites, banks or financial institutions, email accounts from harassing emails or contact, Slack messages, really think very broadly. Clients' emails or messaging accounts, including potentially business ones. Forensic evidence of spyware or stalkerware, like Annie mentioned, this is a really scary form of abuse that we see. And I think, unfortunately, a lot of the time people think that this might be happening and blame some of the behavior on this, but it's really not necessarily stalkerware, because there's a lot of ways we can get the same kinds of information without actually using stalkerware on a device, right? So if somebody says, oh, well, this person knew where I was, they showed up at my work, or they showed up at my kid's birthday party on XYZ date, the fearful assumption is that this person knows where I, is in my email, or they're in my calendar, or they are seeing everything I'm doing on my phone. But there have been many times where the answer is as simple as it turns out that on a phone call that the child told them that they were going to be there, or even that they're on a shared calendar, or that they have shared a location at some point in their relationship and that shared location didn't stop at the time. And so there are kind of lingering ways that information was already shared. So encouraging people to really, it's so important to diagnose where something is coming from so that you can get the proper evidence and really zone in on what's happening, rather than go to it's the most broad form. And this is something that we see abusers do all the time, overstating abilities, overstating what they can do, because that breeds fear, and that allows them to engage in more power and control. I have a client whose abuser is abroad, and we know that because we were able to serve this person abroad. But this person has told my client that, they're able to read all their emails, they know when they're going to law enforcement, and the client was terrified that, oh, I know I can go to the police, I can't go to any assistance. And the more that I asked questions, the more I realized that there was actually, we looked through email filters and forwarding, and there was no way this person actually knew that. They just guessed, oh, I know you went to the police, like valid guess that somebody might be going to the police with this level of harassment. Or they also impersonated me actually as an attorney and messaged my client saying, oh, I need you to join this Zoom so that you can share all of your evidence with me. And, freaked us all out, frankly, until I discovered that, of course, this person knows my name and email because I'm listed as counsel of record on the case. And in fact, this person had just copied and pasted essentially what my name was on the public court record. And so it was pretty clear that's where they got my name from, not that they had actually hacked into any Zoom accounts or anything, even though they wanted to make the client feel that way. Next slide. One thing I should also say in this section, if people have any questions as we go along, happy to, include them in the chat, or we can also do the Q&A at the end. But I know some of this like very nitpicky areas can lend itself to some particular questions. So feel free and I'll try to answer them as I go, or we'll get to them at the end. So when interviewing someone who has experienced technology facilitated abuse, either in the context of intimate partner violence or in the context of workplace harassment or others, it's really important to be sensitive in questioning, right? Avoid victim blaming, engaging in anti-racist, trauma-informed, and culturally competent interviewing and advocacy. I'm sure I'm preaching to the choir here, but really being mindful of the needs of low-income or undocumented clients and the ways in which people might be, might feel worried or ashamed about sharing their story with you, particularly because of the proliferation and constancy of victim blaming, behaviors that we hear from institutions all of the time, right? Well, why did you share that information with that person if you didn't want them to use it against you? Or why did you give them your phone number or your email if you didn't want to be inundated with harassing messages? So just being mindful of our status as attorneys and as privileged institutions when we're talking with people who've experienced this form of harassment and abuse. Next slide. As I stated before, survivor is almost always the main source of the evidence, and it's really important to spend lots of time asking specific questions, starting with a very thorough timeline, advising client and their family or friends not to destroy evidence. May even require as well sending letters, preservation request letters to employers or external companies to make sure that the evidence is not destroyed, because at some point, whenever you may be involved in the case, it could very well be months or even years later, depending on the circumstances. And it's really important to make sure to get as much evidence as you can as quickly as possible. I had a case where a client was a survivor of just extraordinary text message harassment from different free text now, free, I don't even know which website it was, but just free websites where you could sign up and send messages from anonymous numbers, and received literally thousands of messages to herself, to her family, just like the most violent, horrific threats you could possibly imagine about her and her, her child, sexual violence. And she had printed out all the text messages for, at the time, the district attorney. And later, we had it on physical paper, and later her child dropped her phone in a toilet, and so it destroyed all of the text messages. And thankfully, we had the physical papers that we ended up scanning and recreating. But it happens all the time that there's accidental, destruction of evidence. Things can get removed. Abusers themselves will often go in if there is a shared Google Drive, or maybe they have access to a client's password, and delete evidence themselves. I cannot tell you how many times that has happened. So it's so important sometimes to go old school, at least put it on a flash drive, save it somewhere that the abuser may not be able to access it. In some cases, it also makes sense not to block the person that is doing the harassing, right? Allow the survivor to decide and talk through it from a safety perspective. But it may be that there are then continued contact and harassment that is then really important to bring in, particularly if there's an order of protection or some order that requires no contact. I think about this a lot in the Title IX context. We often have people that just can't help themselves from continuing throughout the case to harass and intervene with our client. Attorneys may also need to gather evidence directly, which we'll talk about in a little bit as well. Next slide. So, again, setting up a meeting to gather the client's evidence, capture everything that you can immediately, bringing old phones, photos, recordings, storing them in order, and really the importance of reviewing the entire history with the abuser, with the person that's at issue, is so critical, both for gathering and positive evidence for your case, but also, seeing what may be out there that the abuser is going to use against your client. Next slide. Speaking with clients, trusted family and friends, coworkers, others with permission, conducting your own searches. We love this. Open source intelligence, right? Googling the abuser, reviewing available social media sites. Again, it's been shocking the amount of information you can find online about somebody where other people may have been survivors of similar types of harassment from the same person. Maybe there's things on Glassdoor about other practices that this has been happening, and being able to identify this as a pattern. Discussion boards, there are unfortunately image-based abuse often when it's referred to as this is referred to as revenge porn exchange boards where this is available online, public record searches, social media searches. This is really important. And as attorneys, we don't actually have time to get into this today about ethical implications, but everyone should be mindful that as an attorney, there are obviously ethical implications to identifying and potentially contacting opposing parties, and that certain forms of communication that you may even like looking someone up on LinkedIn, if you don't have your LinkedIn settings turned off to, for instance, send a notification to someone, when you might accidentally send a notification to them that you viewed their LinkedIn page. So please make sure that you are familiar with the settings that you are utilizing, because you don't want to, accidentally either tip someone off that you're investigating them, or even worse, potentially essentially contact a represented party by sending them such a contact. Next slide. So we're now on to preserving evidence. Next slide. Screenshots should include, and some of this will be, of course, I hope obvious, but if it's a website URL, that should include the URL itself, the date and time of capture, the name of the sender or profile, idiosyncrasies about the perpetrator, right? If there are particular ways or language that a perpetrator uses, even if they are using it from an anonymous website or an anonymous text message, you may be able to notice that, right? If they make the same errors over and over again, or if they're mixing languages in a way that is very specific to them. Or I've had abusers repeatedly not identify themselves, but then identify themselves by a nickname, or the client by a nickname, or the child by a nickname. And so we're able to identify them that way. Captured evidence should never appear incomplete. It's really important, especially with screenshots. We see this all the time with like half of a screenshot or part, it's very clearly been cropped. Anything should overlap into the next one. Voicemail recordings should also include the date, time, sender information. Remembering what not to include, one big one is if clients have the other party saved in their phone or even in their email as a name that you may not want to include. I've had a lot of colorful names that people have included their abusers as. It's mostly useful to just delete the name and just have the email address or just have the phone number, right? Because then it's very easily identifiable, right? This is from phone number, whatever it may be, rather than a name, which could be, I could go on my phone right now and I could change any phone of mine, in my list to be Annie's phone number, even though it's not actually her phone number, which could be manipulation of evidence, which would not, of course, not be ethical, but is certainly easily done and could be manipulated by the other party to argue against it. Next slide. Yes, screenshots of phone or computer, downloading voicemails. The other option is using another device to take a photo or a video, using a screen recording software, saving things to CDs or USB drives. I really enjoy SMS backup and restore. As a nonprofit attorney, it is a free, application, and you're able to get. I recently got about 4,000 text messages off of a client's phone that would have been, just absolutely prohibitive to try to download. If you have an iPhone or some other iMessage, it can be easy to export that to PDF and then use it in that way. Forensic investigation is great, but very, very expensive. I also had that for a client recently where they were able to, forensically copy over essentially a full copy of the client's phone, but it was thousands and thousands of dollars, which, I think for clients too, people appreciate you saving them money as well. Next slide. I already talked a little bit about this, but removing abuser from contacts before preserving so that it just has their phone number or email address. Having someone doing gathering who is not covered by attorney-client privilege, or who's not going to then be put on as a witness. You don't want to have an attorney as witness. So being able to have somebody go through, I often have project assistants or other people in my office do it, so that if I need to call them as a witness to authenticate it, if my client's unable to, then that is a great one. It is sometimes possible to recover deleted information, but it's quite difficult. And being careful not to connect your client's device to your computer, especially where you have any concern about hacking or spyware or stalkerware. Next slide. Subpoenaing a tech platform, frankly, it's quite difficult, time consuming, and most of the time the information is not necessarily provided. However, you can send a preservation or litigation hold letter and then a subpoena that conforms with your state rules. One thing I often do is just, try to get basically all of the information that you can without using a subpoena. And then if you need to go to that step, then it is possible, but also very difficult. Next slide. And finally, admitting evidence. Next slide. So again, we already talked about, making sure that evidence is in the right format. Depending on your court, depending on your state, you may have evidence that is, more easily or less easily admitted electronically. There is no need to admit the actual survivor's computer or cell phone, despite some objections under the best evidence rule. In New York, there is something called a notice to admit, which is fantastic, and that you basically say, we're going to be admitting this, and if you don't object within a certain time frame, it's going to come in. And sometimes, people miss that deadline and they don't really have the ability to object, which is fantastic. Next slide. Testimony of a witness can authenticate a documentation or evidence. Mostly it's going to be our client, but it could also be, again, someone from your office that helped collect it, or an external person that may have done a forensic evaluation. Again, most of the time in our cases for nonprofits, it is the client themselves. Circumstantial evidence as well, right? If you don't have the identification of somebody who has repeatedly contacted or impersonated your client, adding in, information that may lead to looking like that is the person that has done it, can be really helpful. Stipulation, of course, not one that we often see in domestic violence cases, but in theory possible. Expert testimony. And remember, of course, that once evidence is authenticated, challenges to the authenticity go to weight and not admissibility, which I think is one of the best things, except when we get to something like an authentic image, like a deep fake, which can be tough because some of the things will come in. Next slide. I'm going to skip through a little bit of this because I think that we are essentially have repeated a little bit, but competent witnesses can testify. Really, you don't need anything more than that, at least in family and typically in the courts that I practice in, although every court is different, of course. Next slide. Oh, Annie, if you want to pop on, do you want to pop on that one?
Oh, no, you can finish. I was just going to say a couple things, like a
Okay,
couple.
okay. Next slide to text messages. Fair and accurate representation of messages received on XYZ date. How do we know that it's from the other person? How many times have they communicated with them? Using circumstantial evidence if the number is unfamiliar to the client, right? Nicknames, insider knowledge, testimony they routinely communicated via text, sequential text messages, and if possible, establishing the message came from a device under the other person's control. That's not something that I'm often able to do. Usually we can get it in from the other methods. Emails. Last one, next one. Testimony of the conversation participant that the emails are the correspondence. It's a fair and accurate representation of the emails that were received. And then again, authenticating like you would any other messages. You can also attempt to trace IP addresses using the native file of the email, and pursue the use of expert witnesses to explain if the email has been spoofed or misused. And next slide. And I will give this one to Annie, actually, if you want to jump in and then also finish whatever you were going to say, because this is your.
You did great, Linz. You just covered so much. I really encourage people to like just I don't know if they'll share slides, but you can also get in touch with Lindsay and I anytime. We have lots of materials to share on these topics. But I just want to emphasize that, this stuff that Lindsay and I are talking about in terms of advocating, this is all inside of the civil court context of one variety or another. Oftentimes we're in family court or civil court. Otherwise, the evidence standard is lower than in criminal court, right? We're at the preponderance standard. And oftentimes we're just sort of like asking the court to apply their common sense. Because in the situation of tech abuse, oftentimes the defense that we get, the common defense is, she did this to herself in order to make me look bad or to get attention. And in cases where someone is the victim of just like really egregious tech abuse, I think it's important to ask the court to apply common sense, and say like, does it make sense that the client would send her nudes to her own employer in order to maybe someday be in court with this person to maybe get an order of protection? Like, obviously I would do it in a more eloquent way than that. But I think that it's really important to remember that good storytelling, common sense, don't include every screenshot in fact, and you just like narrow it down to what needs to be said. And one of the most common misconceptions is that about screenshots having to do with screenshots are a photograph of a crime scene, and a person who was a party to that conversation, right? So if I get a text message on my phone from a person and I screenshot it, I can authenticate that as a witness to that communication because I was a party to it. So, those are sort of, and sometimes we'll get defense objections about best evidence rule and you need to submit the phone for forensic examination, but that's actually not true. And we have lots of case law to help support that if you need help making that argument. That's all I wanted to say at the end was just, don't get weighed down by technicalities. Don't feel like you have to say every fact. Tell a story that makes sense. Pin the circumstantial evidence to the, to the abuser, and rely on your client's credible testimony in a story that makes sense and makes more sense, essentially, in the preponderance standard than your opponent. It's not that easy, obviously. It's hard, but it is doable. And oftentimes there's some, kind of myths we like to crack around digital evidence and what's admissible and not. That's all I wanted to say. Ta-da! We did it.
Thank you all so much, Marianne, Annie, and Lindsay. Thank you for addressing that topic so thoughtfully, thoroughly, practically. I think this was a really helpful combination of a broad overview of the landscape and also specific tangible advice. So just really, really appreciate that. We have about 5 or so minutes for Q&A. So you're welcome to either add a question to the chat if you have it. You can also use the Q&A function. Someone did ask Marianne for some extra additional information about the task force, which we added to the Q&A. If you had anything to follow up about that specific question, by all means, feel free to add that here. But I'll give folks a minute or two to jump in with a question. And I know that in an effort to adhere to the timeline that we had set out before you all started, you did an incredible job of getting through a ton of content, but also since we have a few minutes tonight, I'm not seeing anyone jump in right away with a question. If there was anything that you felt like you sort of gave short shrift to that you wanted to take one more minute to elaborate on, I don't want to put anyone on the spot, but want to name that there might be an extra minute or two.
I thought of one thing I wish I had mentioned, which is, we talk a lot about intimate partner violence context, but in the context of employment, there's some exciting developments in the law that Marianne talked about at the very beginning, the new federal cause of action where you can sue. It's a civil cause of action, not criminal, in the federal courts for disclosure of intimate image. And there's some cases of very recent cases that have been filed, and one that has overcome a motion to dismiss where a company has been held liable under that same statute because they knew or should have known that their employees were disseminating intimate images. The case I'm referring to is T-Mobile, where they're showing a pattern and practice of T-Mobile employees taking images off of a person's phone when they come to have their phone fixed. But there's another case developing in Pennsylvania where an abusive husband worked, and he used a company conference to disclose an intimate image of his ex-wife who worked at the company. And they've brought in that civil cause of action, which I think was written and meant for mostly for sort of like to be a federal version of the state laws, but to see it applied to companies and corporations and potentially employers is very exciting expansion of justice for victims and is probably relevant to some folks here. So I will find the Pennsylvania case and I will share it with you because I don't know it off the top of my head, but I will find it and we can share it.
We have a couple questions in the chat. Thank you to Michael and Azalea who have added some questions. So the first one is, one of the slides talked about stalking via shared apps like Netflix or Amazon. And you were saying that a stalker can open the same shared app and see what was last viewed on Netflix, the location where it was viewed, what orders were made for shopping at Amazon, right? So sorry, you were saying that is how someone could use those apps like Netflix to see like the location where they viewed something, where they had something shipped, but you weren't saying that these apps allow constant GPS tracking or access to info from other apps. So just some clarification, it sounds like, on how some of those shared apps might allow folks to further their stalking. And Annie, I see you.
I didn't mean to because Lindsay.
Okay.
But I was going to say, depends on the app.
Yeah.
Uber lets you, and if you go through, like, if you're on an iPhone, for example, you can see what the sharing functions are. So there are some apps that if a person has access to, that they can see your they can see your contemporaneous location. So it's really important to know what apps you have and what your location sharing settings are.
And Michael, if you had any kind of follow-up to that, feel free to chime in with a sort of follow-up question. But I will jump to Azalea's question. So what do you think is most right? ripe for reform, what's most in need of a legislative fix in this space. Whether you want to, I know we have a lot of New York focused folks here, so whether you want to speak to New York or specifically Dr. Franks, if you want to speak more broad than that, would love to hear what you all have to say on that piece.
Yeah, my quick response on that would be passing Shield. This would be a tremendous step forward, and we've been hoping for it for so many years, and it would really fill in a lot of gaps for states that are falling short. So we were, of course, thrilled that New York did pass the non-consensual distribution of intimate imagery law, but as was mentioned before, it does have that requirement that there be motive, right? And so motive to harass or hurt the person. Love to see if New York could on its own fix that statute. We're trying to encourage all states to get rid of those motive requirements. But what we really would love to see is if we could get this passed at the federal level. One of the other reasons why it's really powerful and important is because Section 230 has come up a couple of times about tech industry immunity as a shield. One of the things that would be very useful about passing a federal criminal law is that Section 230 has an exception for violations of federal criminal law. So even if we don't change Section 230, if non-consensual distribution of intimate imagery became a federal crime, you could no longer invoke Section 230 as a defense against it, and that would be incredibly helpful.
And then just a quick follow-up to that is, what's the opposition to Shield?
It may or may not come as surprising to you, but the opposition had mostly and continues to mostly come from groups like the ACLU, the Electronic Frontier Foundation, other civil liberties groups that claim that if you are going to try to regulate non-consensual distribution of intimate imagery, you have to do it in a way that requires intent to harm. So there's a deliberate kind of misuse of First Amendment doctrine here, because that's not what the First Amendment says, but it is basically the view, a little bit like with the Cowerman case, that this form of behavior, stalking, delusional stalking or revenge porn, that this is protected free speech. So that's mainly the battle. And because they've lost that battle in a lot of straightforward ways, that legislature still wanted to pass this law, the way they've managed to sort of fall back is to weaken the law quite a bit by putting in this intent to cause distress element, which is very hard to show even in cases where there are clearly feelings of personal vengeance. You still, as a criminal matter, having to prove that that was the motive beyond a reasonable doubt is a really, really high bar.
Thank you. And let's wrap up with this last question. Does any of the new legislation you referenced in the beginning include an application to schools or holding schools accountable for not handling or addressing cyberbullying or harassment or stalking?
I will say that the Defiance Act attempts, I believe there's language in Defiance that tries to talk about education and the role of schools in particular, and the impact this has on minors. But I would really want to emphasize too, and I'm sure that Lindsay and Annie could probably speak to this, and many of you on the call can speak to this, that you don't have to wait for a new law about this, that it should be the case that there's Title IX issues that you can raise with these cases. And I think in some of the high school and junior high cases, we've actually seen some Title IX issues being raised, because if you can show, right, that the school is deliberately taking those steps here, there should be a lot that can be done with current and existing law, because they do have obligations.
Great, thank you so much. And Annie, I see you adding your contact information to the chat. Appreciate you sharing that. That's really generous. I am going to wrap us up because we're at time. Before folks log off, we are going to launch a survey for the webinar. If folks would just take a brief minute to provide your feedback, that's really valuable to make sure that our webinars continue to meet your needs. And I want to thank our fabulous presenters, Marianne, Annie, Lindsay. Thank you for all of the time and thought you put into preparing for this webinar and your presentation today. And thank you for the critical work you do every day to protect survivors of technology-based abuse and other harms. Thank you all who attended today. Really appreciated your engagement and your excellent questions. Again, if you could just take truly a minute to fill out the survey, that would be fabulous. And I will say goodbye to everyone. And yeah, thank you for attending, and thank you to our presenters. Really fabulous.
Thanks, everyone. Stay safe out there.
Thank you all.
Okay, I think we have full participation, so I'm gonna finish us off. Thanks.
Thanks, Ian.